So we're ready on Riggins? Is that right?
Yes, sir.
All right. So on the record on docket 23-00125, People versus Jeremy Lynn Riggins. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Edward Hess on behalf of Mr. Riggins. Mr. Riggins is not present today, either in person or by Zoom. I received yesterday from the Sacred Heart Rehabilitation Facility in Richmond, Michigan, a letter of admission indicating that Mr. Riggins had been admitted to their program. I wrote back informing them that Mr. Riggins had court today and that he was required to appear in person, that if he couldn't appear in person, I would at least like him to appear by Zoom. The person who wrote back to me, whose name is Mr. Doan, informed me that they would not accommodate Mr. Riggins appearing by virtual court and asked me to request that Mr. Riggins' matter be adjourned. I reached out to Mr. Wisty. Mr. Wisty said he was fine with that. I wrote back to Mr. Doan saying that Mr. Wisty and I would ask for that, but it's not official until and unless the court grants the adjournment. So therefore, at this time, Your Honor, I'm asking that in light of Mr. Riggins being in a treatment facility and his admission to which has been verified with the writing shared with the prosecutor, that this preliminary examination be adjourned.
And what's the name of the facility?
It's called Sacred Heart.
Sacred Heart.
And there's a whole bunch of facilities. He's in the Richmond, Michigan facility, which is in Macomb County. The letter indicates that he doesn't indicate how long the stay will be. It begins with detoxification, which is, and it's anywhere from 3 to 5 days up to 30 days of residential treatment. An average length of stay is approximately 10 to 21 days. It indicates that Mr. Riggins was admitted yesterday. So I would ask for an adjournment of at least 3 weeks in order to accommodate a potential 3-week
All right.
time in treatment.
It's my understanding that this would German be a request at the defense for good cause because he has not waived his 21-day rule from my notes. Is that correct?
That's correct, Your Honor, but clearly with him being absent from the court.
We got a problem.
Yes, Your Honor.
Mr. Wisty, your response?
Everything that is accurate, Your Honor. I believe more than appropriate.
All right, so we will adjourn for good cause. For good cause. The defendant has not waived his 21-day rule rights, but he is in custody at that's an inpatient facility, I assume.
It is.
If he can't get out,
It is an inpatient facility. It's called the Sacred Heart Rehabilitation Center.
All right.
Incorporated. And they've got a whole bunch of locations in Michigan, but he's in Richmond, Michigan.
All right, and let's get a date 3 weeks out for now, or around 3 weeks out. That'll put it at the time.
February 23rd at 8:30.
February 23rd at 8:30.
Thank you, Your Honor. I will note for the record that Mr. Wisty, whom I believe is not going to be the assistant prosecutor for much longer, has extended a generous offer of trespass with Mr. Riggins' agreement to pursue continued mental health treatment.
All
That's
right.
correct, Your Honor.
And with that offer having been extended, I am confident that there's a very good chance this case will be resolved in district court.
All right. And Mr. Wisty, you'd indicate that was the offer, was trespass with mental health treatment.
Yes, Your Honor.
All right. All right. So this is reset for February 23rd at 8:30, adjourned for good cause because the defendant is in treatment, in an inpatient facility treatment. Anything else for the record? Docket 23-00125, Mr. Wisty.
No, Your Honor.
Anything, Mr. Hess? Thank you. That's all for the record, Ms. Powell.
Your Honor, with respect to
You just turned this on.
we're on the record in docket. We'll do the 2203-253 first. That's the older file. So 2203-253, people of the state of Michigan versus Juanita Edwards. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Your Honor, Edward Hess on behalf of Ms. Edwards. Ms. Edwards is to my right, counsel table.
Ma'am, you are Juanita Edwards?
Yes, sir.
All right. This is the time set for preliminary examination today. Mr. Wisty, how are we proceeding?
Your Honor, we'd be proceeding with examinations.
All right. Is that your understanding, Mr. Hess?
It is, but I do have to make a record and inquire of my client briefly. I was advised this morning by Mr. Wisty that if the case does proceed with preliminary examination and the proofs allow it, Mr. Wisty will be moving to add a charge of felony firearm to this file. That carries a mandatory 2-year prison sentence. It's important for my client to know that that's a serious statement from the prosecutor. If she were to waive her preliminary examination, the case would go to trial, would go to circuit court with just the charges on the complaint. It is possible for the prosecutor to add that charge at trial anyway. But I just have to advise Ms. Edwards that she does have the right to that hearing. I'm prepared for that hearing. But the prosecutor has advised me this morning there's an intention to add charges. That was important for Ms. Edwards to know about that.
Ms. Edwards, do you have anything to say in regards to your attorney's statement? Okay.
I have to make a decision.
All right.
Well, you don't, I'm sorry, may I speak?
Sure.
Yes. Ms. Edwards, you've already indicated that you want your preliminary examination. The prosecutor didn't make any kind of plea offer. That's why we're here today. The prosecutor has told me today he intends to add charges. So, and I just, I didn't have a chance to meet with you before you got brought up to court. So I'm just advising you that the prosecutor, if the evidence allows him to, might add charges, which would make this case more serious.
Would you like a moment to speak with your attorney about that? All right. I'm gonna give you a moment to
Okay.
speak with your client, and you can use this courtroom, okay?
Thank you, Judge.
I'll make sure that the We're back on the record in docket 22-03264. Mr. Hess, have you had the opportunity to speak with your client concerning some of these preliminary examination issues?
I have, Your Honor, and with that information we were given by the prosecutor this morning about the intention to add charges if these hearings are run, I felt it was very important to advise Ms. Edwards of that. We appreciate the court giving us some time to meet in private. And Ms. Edwards and I have reached the decision that on each of these files, Ms. Edwards will be waiving her right to preliminary examination this morning, understanding that that will be an unconditional waiver and she will be bound over as charged under current complaints without the addition of any charges.
Right, but is that your understanding, Mr. Wisty? There'll be no, this will be a full preliminary examination waiver today.
Yes, Your Honor.
All right.
Judge,
Yes.
you said that we were in the case in 6-4. I have a summer record on 5.
I have this 5-3.
Okay,
Yeah.
Judge.
Let's redo, let's make sure we're on the right one. So the earlier file 22-03253. And so counsel, may I inquire of your client of their waiver of the prelim on 22-03253?
Yes, please, Your Honor.
All right. Ms. Edwards, you understand you have the right to a preliminary examination in district court today?
Yes, sir.
And a preliminary examination is a probable cause, is a probable cause conference in which the people of the state of Michigan would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. That's what we're here for today, all right?
Yes, sir.
And they'd put on any witnesses they have and the testimony would be preserved. And you're of course represented by Mr. Hess, and he would cross-examine or contest any charges brought against you. You understand that?
Yes, sir.
Okay. You understand that you have a right to that prelim. And if you waive your prelim, you'll be waiving your right to your preliminary examination in district court. You'll be going to circuit court. You won't be preserving any testimony here, which is an idea, right? And you'll go to circuit court, and in circuit court, that's the trial court. So that's where this case will continue. Do you understand that, ma'am?
Absolutely.
Is it your intention today to waive your right to a preliminary examination in this file 22-03253?
Yes, Your Honor.
All right. I find the waiver to be freely, understandingly, and voluntarily made. Negotiations are to continue in this case in circuit court. There's no formal plea offer. Is that correct?
Correct, Your Honor.
Okay. So negotiations are to continue. The prosecutor also waives their right to preliminary examination. And I will accept the waiver and bind it over to circuit court, where you'll proceed in circuit court. Keep in contact with your attorney, Mr. Hess. He'll provide you with any subsequent date in this file, but your time in district court here will be done. All right, ma'am?
Yes, sir.
All right. Anything for the record in docket 22-03253 on just this file, Mr. Wisty?
No, Your Honor.
Anything, Mr. Hess?
Yes, Your Honor, thank you. And this will be applicable to both files. Ms. Edwards has been ordered by the court, if she posts bond, to be fitted with a GPS tether with victim notification. She's been informed that the tether company isn't sure where the alleged victim in this case resides. So I've asked Mr. Wisty privately to approach the court off the record and to give him his best address for where the alleged victim resides, so that Ms. Edwards can comply with that court order and hopefully be fitted with the tether and be released from the jail while this case is pending.
And then it would be my intent to confer with the victim who is here when we're off the record and approach the court to make sure that address is.
All right. And even to make it more, non-transparent as to the victim's address, if you provide that to Wendy, the court officer, she'll make sure the GPS device knows, the court recorder, she'll make sure that the GPS company knows the address to put as a part of that 2000 order. Of course, right now she can't stay away from where she doesn't know, but that'll be a part of the address will be the exclusion zone for the 2000 feet on both files, since they both have the same victim. Is that fair, Mr. Wisty?
That is fair, Your Honor.
Any, Mr. Hess?
Yes, thank you.
All right. So so that's all for the record in 22-03253. And then let's go ahead to 22-03264. This is the time set for preliminary examination. And Mr. Wisty, are we proceeding the same way on this file as we did on the previous file?
Yes, Your Honor.
All right. Mr. Hess, is that your understanding the defendant's going to waive, Ms. Edwards is going to waive her right to preliminary examination in this file also?
That is correct. And that is because she has been fully informed by me of the prosecutor's intention potentially to add charges. And she and I both discussed it in detail, and she's asking the court to accept her voluntary and unconditional waiver of preliminary examination, with the case being bound over as charged.
All right, thank you, man. Inquire your client of the waiver.
Yes, Your Honor.
All right. Ms. Edwards, similarly in this case, as to the last case, you know, you have a right to preliminary examination in district court. You understand that, ma'am? And a preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime is committed and the identity of the person who committed that crime. Do you understand that, ma'am?
Yes, sir.
Mr. Hess, of course, would be here representing you as a public defender, and he would cross-examine and contest any charges brought against you by the people today. Do you understand that?
Yes, sir.
It's my understanding that it's your choice to waive your right to preliminary examination unconditionally, and negotiations are to continue in circuit court, but you're going to waive your right to a preliminary examination today in district court.
Yes, sir.
All right. Mr. Wissy, prosecutor also waives their right for prelim.
Yes, Your Honor.
All right. With that understanding, you'll be bound over to circuit court on the charges in the complaint and warrant. Because you waived your right to preliminary examination, I find the waiver to be freely, understandingly, and voluntarily made. The only plea agreement right now is negotiations are to continue. Okay, ma'am?
Yes, sir.
All right. Please keep in contact with your attorney, Mr. Hess, and I'll give you both files. And they will provide you with your circuit court arraignment date. All right, ma'am?
Yes, sir.
All right. Anything else for that file, docket 223264, Mr. Whisky?
No, Your Honor.
Anything, Mr. Hess, except the address, to make sure the address is continued in regards to the no contact zone?
Nothing further. Thank you.
All right, thank you. That's all for the record in that file. We'll have you sign the waivers, and then I'll sign them after you. So we're on the record in docket 20-03373. People of the state of Michigan versus Joshua M. Taylor. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Taylor, who is present and standing to my right.
Sir, you are Joshua M. Taylor?
Yes, Your Honor.
All right. This is the time set for a preliminary examination today. Mr. Wisty, how are we proceeding?
Your Honor, we've reached a resolution where the defendant will plead guilty to an added count 2 of use of a controlled substance. The PAC code is 333.74042A. This is 1 year and or $2,000. And in exchange for that, count 1 will be dismissed, Your Honor.
All right. So let me make sure I have that correctly. Mr. Milks, my understanding of the plea agreement is your client will be pleading to an added count 2 of use of cocaine pursuant to 333.74042 parents A. That's a 1 year and or $2,000. With a plea to count 2, count 1 is to be dismissed. That's the possession of cocaine felony.
It is, Your Honor. For the factual basis, it is heroin.
Okay.
And just for the record, I spoke with Mr. Wisty about a potential for 7411 in this matter. It turns out my client does have a use of marijuana or possession of marijuana apparently from 2017. And even though marijuana is legal now, I couldn't find a carve out for 7411. It's not part of the plea deal or anything, but I just want to let my client know that we did contemplate that.
All right.
Mr. Witten looks like we can.
I'm most likely going to refer this to probation, but if that but I'm not certain on that, and I'm not certain whether they carved out that. So, Mr. Wisty, anything on that?
Believe it makes him ineligible.
I believe so, but I'm uncertain as to how they grandfathered all those past convictions in. With that understanding, may I inquire of your client of his advice of rights? I noticed you did sign an advice of rights. May I inquire of your client?
Yes, Your Honor. Thank you.
So, Mr. Taylor, it's my understanding you heard the negotiations and the indication that you're going to plead to account and account will be dismissed. Is that correct, sir? Right. You've signed an advice of rights indicating that you understand your rights and you signed that in regards to that. All right. I'll only go. There's only 3 big rights here that we'll talk about, and I'll walk you through. You know you have the right to trial by jury or judge, right?
Yes, sir.
And you're waiving that today.
Yes, sir.
You have the right to you have the right to counsel, and you have counsel with you today, Mr. Milks.
Yes, sir.
Correct? All right. And you have the right to silence. The people cannot use your silence against you in a trial of any kind. Is that correct?
Yes, Your Honor.
All right. With that understanding, you're waiving these rights, these trial rights, and you're pleading guilty today. Is that correct?
Yes, Your Honor.
All right. I don't have to do this, but I'm going to do this. Raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right. I'm going to bring you back to the date of June 10th, 2020, at the offense location of 1363 Roosevelt, City of Lansing, Ingham County. Were you at that Roosevelt? Were you on Roosevelt in the City of Lansing in Ingham County on June 10th, 2020?
Yes, Your Honor.
Okay. And what did you do in count 1 or count 2, the added count 2, which would be what did you do in regards to the use of a controlled substance on that day?
I possess heroin.
Okay, you possessed heroin, and that would be the factual basis for count 1. So that would be so, and you do so. You possessed it knowingly. You knew it was heroin when you possessed it.
Yes, Your Honor.
All right. Any questions concerning the factual basis, Mr. Wisty?
No, Your Honor.
Any questions, Mr. Milks?
No, thank you, sir.
All right. I find the factual basis to be understandingly, voluntarily, and accurately made. I'm going to set this for pre-sentence. So the defendant is to be contacted by probation And do we have a date of sentencing?
April 18th at 1:30.
So the sentencing date will be April 18th at 1:30. In the meantime, you'll be contacted by the probation department. They'll go there, talk to you, answer any of their questions. They'll prepare a report for me and then we'll go from there, okay? We'll see what options are available to us.
Okay.
All right, anything else for the record, Mr. Wisty?
No, Your Honor.
Anything, Mr. Mills?
If we may be heard on bond, Your Honor?
You may.
I believe the court left it open. We did make a request last time. The court denied it, saying we wanted to see what would happen regarding today, Your Honor. Your Honor, we are requesting a PR bond. I'm just going to reiterate a few of the things that I said last time. We'd be requesting probably a GPS tether because the court alluded to some concerns regarding past failure to appears. However, my client has been in jail for just under 30 days, Your Honor. He has gone through complete detox, which is always the most vulnerable period for an individual. We've been discussing potential MRT, if that's gonna be available for, or MAT, I'm sorry, Your Honor, for him, if that's gonna be available. It's my understanding that he does have employment if he were going to be released, and that he would be living with his mother. It's my understanding that his mother and stepfather do not have alcohol in the house, or at least do not consume alcohol, and they do not have or use controlled substances, Your Honor. And he understands that there would be an amount of testing likely involved too. Finally, there's going to have to come a point where we're going to need to trust him in the community, trust that he's going to come back, and he's got no greater incentive to make sure that he's coming back than between now and the time of sentencing, Your Honor. Kind of giving him enough rope to hang himself with or prove that he is worthy of probation. Thank you, sir.
Thank you. Mr. Wisty, any response?
I would, as the court is aware, there were some issues in the appearing report earlier. I would request a tether if he is granted.
All right, are there any, I don't have a CCH. Are there any assaultive crimes concerning the defendant's prior criminal history? I guess that's essentially what I'm looking for is for any,
Yes, Your Honor, but there'd be a misdemeanor domestic violence in 2006. 2009 was another domestic violence.
So those are both over 10 years old.
Another one in 2017. So there's a history of a domestic violence here. Last one is 2017.
All right. Mr. Taylor, I'm going to order today that you be placed on, I'm going to reinstate the $3,000 PR bond, all right? You understand the conflict I have. You have some assaultive behavior. Most of it's over 10 years old. There's one over 5 years old. It's all domestics, and that gives me pause to let you out. However, your attorney is right. I mean, on some level, you're going to be trusted here in order to do, in order to continue with your sobriety on some level.
Correct.
And I'm not a stranger to that process in regards to understanding that at some level, we have to trust you. And because the ultimate decision is yours,
Right.
you know, and whether you're successful or not comes down to whether this is the time or not.
Right.
And so I am going to order a GPS at the prosecutor's request. So it'll be, the defendant is GPS tethered. We don't have a victim in the case in the file, so I won't make a victim notification, but we require a GPS requirement. And all the same conditions apply. No assaultive behavior, no drugs or alcohol, no out-of-state travel, no firearms. And then so you should, once you're out, you'll have to report to probation within 48 hours.
Okay.
All right, so within 48 hours, report to probation, which is on the 5th floor of this building.
Okay.
Within 48 hours. And that'll set it up. If you don't report, they'll just revoke your bond again and you'll be right back where you started. So that's what we want to avoid, right? All right. With that understanding of the GPS ordered, bond is reset at $3,000 PR. report within 48 hours. That your sensing date is April 18th at 1:30. That's kind of going into my equation also. It's an April 18th date. It's out there a bit. And so you'd have a lot of time in. So this is time for you to work on yourself
Yes,
to
Your Honor.
make sure that you stay sober, okay?
Yes, sir.
Anything else, Mr. Wisty, in regard to this file?
No, Your Honor.
Anything else, Mr. Mills?
He'll probably be released probably after 5 today or something. Monday, I assume, for losing the 48 hours.
Perfect, yeah, actually Tuesday by 4. Yeah,
So, yeah,
Tuesday by 4, all right.
thank you, sir.
All right, anything else?
No,
All right, we're all set. Thank
Thanks,
you,
Your
Mr.
Honor.
Milks. Thank you, Mr. Wisty.
Appreciate it.
Down to people be Olds. Have a nice weekend, Mr. Milks. All right.
Very much.
On the record in docket 23-00129. That's people of the state of Michigan versus Leandre Germain Oles. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Edward Hess on behalf of Mr. Olds. Mr. Olds is to my right at the council table, having been brought up in custody.
Sir, you are Leandre Oles?
Yes, Your Honor.
All right. Mr. Wisty, this is the time set for preliminary examination today. How are we proceeding?
I will be proceeding with the preliminary examination.
Okay. Are there any pretrial matters to be brought to the court's attention before we start the prelim? Are there any preliminary matters to be brought to the court's attention?
Nothing from the people.
Anything, Mr. Hess?
Nothing further. Nothing at all. Thank you.
All right, we'll sequester witnesses just for purposes of the preliminary examination. I'll leave it to counsel. If anybody comes in that you anticipate might be called, maybe it's best they don't hear the testimony. With that understanding, Mr. Wisty, you can call your first witness.
Call Lynette K. Fair. Far.
All right.
We'll be showing a video and go ahead and get hooked up to the.
Sure. And the court officer can help you if you have any. He's kind of our court officer / technological
This guy here.
Zoom master type of. So ma'am, you can come this way. I'm gonna have you stand right in front of me and state and spell your last name for the record.
My first name, Lynette Farr, Lynnette, represent Frank, ARR.
Okay, please raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury. All right, thanks, ma'am. Have a seat, project to the back of the courtroom for recording purposes, because you're being recorded, all right? So if I interrupt you at all, it's only because we can't hear you, okay?
Okay.
All right. And you can get yourself all settled there. All right, Mr. Wisty, when you're ready to proceed.
Thank you, Your Honor. Thank you for being here, ma'am. Could you state your name again for the record?
Lynette Farr.
And Ms. Farr, what do you do for employment?
I am the site manager at Riverfront Apartments,
Where is that located?
601 North Cedar in Lansing, just downtown.
What county is that?
Hingham.
As a site manager, are you aware of the surveillance system that department has?
Yes, absolutely.
Can you
I-
explain a little bit more about that surveillance system?
Yes, I have a big monitor in my office and I have cameras all on the first floor. I have cameras down each hallway, which my apartment building has 10 floors. So I can see down each hall and then in the laundry rooms.
And does that system keep the date? Does it have a date tracking system?
It does.
And then if you could direct your attention to the screen there, can you tell me what we're looking at?
We are looking at the 6th floor with apartments starting at 610.
And can you tell me what date this is from?
I cannot read it from here, to be honest with you.
May the witness have permission to approach the screen?
She may, or I mean, yeah, she may. You know where it is located.
Up at the
The
top.
date on the top, yeah. So if you need to position yourself in a better to see it, you may.
October 17th.
Okay.
And then, Your Honor.
So let the record reflect that the witness has approached the video recording and is indicated October 17th is the date.
Then, Your Honor, at this point, I would move to admit this into evidence and play the video clip.
Any objection? For preliminary examination purposes.
Your Honor, objection for lack of foundation for this video.
Okay, ma'am, is it part and part of your job to review and to keep all of these videos? Or
Yes.
at least to review these videos as part of your job?
Yes, if a resident has come to me with a certain situation, they will ask me if I could go back and check on our cameras, and this is one of those cases.
All right. With that understanding, I'm going to allow it for preliminary examination purposes. So objections noted, and People's Exhibit 1 is admitted.
Thank you, Your Honor. I apologize.
And we'll make a record right now while we're waiting that just for the record, the courtroom is viewing a video on the monitor, which indicates that 6 Flores described by the witness on October 17th, 2022. And I started this at 2:28:50, and we're now at 2:40:43. With an individual walking into the far apartment door on the 6th floor.
Pause right there. Ms. Farr, could you just briefly describe what we just witnessed on the video?
The gentleman in the video was walking down our hallways, checking for unlocked doors.
And that would be the second gentleman. That would be
Or
the one we just saw.
yes.
Okay.
And then he ended up making his way into apartment 615.
And do you have in your capacity as I'm sorry, what was your title at the apartment complex?
I'm the site manager.
As a site manager, do you have some knowledge of who lives and who does not live in that apartment complex?
Correct.
That particular individual, have you ever recognized, seen him before?
I have not.
That apartment he entered, do you know who resides in that apartment?
I do. It was, don't you release the name?
Yes.
It was Josephine Torres, who's actually no longer a resident.
The apartment he entered?
Just now is 6:15,
Okay.
Josephine Torres.
And then right there, he's also exiting Josephine Torres' apartment.
That is correct.
Your Honor, if I have a brief recess to speak with my witness here, I believe I may have queued up the wrong video.
All right, I do have that the indication of the individual leaving is 2:47 at 52. And then that's the final date on this video, right, on this exhibit?
Yes, Your Honor.
All right,
Your Honor, the witness is under oath. I would object to her meeting with the assistant prosecutor. She's already under oath. She's already under a stand. If he wants to show another video, let him show another video.
it'll be subject to cross-examination that this took place, so I don't have any wherewithal in regard to the exhibit, but you certainly can cross-examine on the break. And I'm certainly aware that counsel has started the testimony, had a meeting, and then crossed on it. However, it's not unusual to break up testimony, so I'll allow it. The objection's overruled. So, ma'am, if you want to meet with the prosecutor for a few minutes, that's fine. When you get back here on you'll still be under oath, okay?
Okay.
And Mr. Wisty, you may proceed.
Thank you, Your Honor.
And this is the same exhibit?
This is the same exhibit, Your Honor.
Okay. So we're back on the record and reviewing the plaintiff's exhibit 1.
If I may, I'm going to skip ahead.
Okay.
If I may approach the witness, Your
You
Honor.
may. So you've skipped ahead to 248
Yes.
and you're now approaching the witness. You may proceed.
Yes. So may the record reflect I'm showing the witness what's been labeled as plaintiff's exhibit 2. Can you tell me what that is a depiction of?
It is an individual with a bag in his hand.
Does that appear to be a screenshot of the video of this witness?
It is.
And that video would have been from, can you tell us where that video was taking place? and what date again, just for the record?
Speak up, Mr. Wisty, but same.
That would be a screenshot from the video we just witnessed.
Yes.
And can you tell us just again for the record, what date that was taken? And roughly what time that was, or what date that was taken and where that was taken in the apartment complex?
It was taken on the 6th floor, October 17th, 16th. I don't know what the date.
It would be the same date as a fair to
Yes,
say.
yes,
It
sorry.
would be the same date as on the video. And I would move to admit People's Exhibit 2, Your Honor.
Okay. And People's Exhibit 2 is a fair and accurate representation from the video.
Yes.
All right. You can show defense counsel. I don't know if you have or not.
Your Honor, I'll object to the admission of this exhibit as cumulative since the video has already been admitted.
All right. I'll allow it as a detail to the video that's already been shown. So People's Exhibit 2 is admitted into evidence.
Thank you, Your Honor. And then Ms. Farr, I've changed to a different video on the screen. Can you tell us what this depicts?
It's the same hallway as I mentioned before on the 6th floor apartment starting with apartment 610.
And what date is this video from? Would it be fair to say it's the same as the
Yes.
corner? And I guess the record would reflect the corner here says 10/16/2022, 09:39:15.
It does.
And this is taken with the same system that you discussed that the other video was taken with.
Correct.
Your Honor, at this time, I would move to admit this video as People's Exhibit 3.
All right. So has this been marked? No. So and any objection, this is a different video. This is a day before October 17th. It's October 16th, but on the same jump drive. But any objection, October 16th, 2022. And then we need to mark, or we can mark it as part 2 of the initial exhibit that was admitted, which would be a B. But any objection, you had a foundational objection to the initial exhibit, plaintiff's 1 exhibit. This seems to be a part 2 of plaintiff's 1 exhibit on some level.
Yes, Your Honor.
I'll just renew the same objection, Your Honor.
All right. The objections noted, the objections overruled. It's the same video a day before. And we'll just say it's part 2 of exhibit 1 at this point in time. or B of exhibit one.
The record reflect I now play the exhibit.
All right, the record may reflect.
Record reflect I'm pausing the exhibit at 9:40:52. Ms. Farr, are you able to tell us what apartment, or can you just describe what just happened in the video briefly?
That gentleman on the screen just came out of 610 Apartments, and her name was Eileen Jacobs with some items in his hand.
And that apartment 610 belongs to an Eileen Jacobs, you said?
Correct.
Have you ever seen this individual before?
I've not,
Have you ever known him to have permission to enter Eileen Jacobs' apartment?
no,
Do you ever have any discussion with Eileen Jacobs about this incident?
I have.
And did you ask her if this person had any permission to be in the apartment?
Yes, they did not. She actually, her aide came down and reported the situation. And, that's when I gathered the information. And then once I found the certain data, I brought them both down and showed them what I had found.
And that's what prompted me doing these videos, and
Correct.
these conversations. Did she ever indicate where she was, if she was in the apartment when this happened?
She said she was sleeping inside her apartment.
Your Honor, I would like to play attempt to enter another exhibit here. I'm going to reflect on changing the video again.
All right, it's the same jump drive.
Yes.
So this would be part C.
And then if the record would reflect, I'm asking the witness to look at what's been part C of People's Exhibit 1. This is a video frozen at 08:42:44. Ms. Farr, is this again captured from the same recording system?
Yes, it is.
And what part of the building are we looking at?
We're on the 6th floor starting with apartment 610.
Is this right here? Would that be where Elaine Jacobs' apartment is?
Correct.
And then at this point, I would move to introduce this again, it's exhibit portion 3 of People's Exhibit 2. I believe foundation has been met based on, it's the same video from the prior exhibit.
All right, so I have, it's the jump drive and has been marked as plaintiff's exhibit 1. And this would be part C of plaintiff's exhibit 1, which is the October 16th date, but a different time period, starting at 8:42:44. Any objection or continued objection as to this was the third video on the same marked jump drive, Mr. Hess?
Let's continue the objection.
All right, thank you. Well, your objections noted. I'm going to allow it for purposes of preliminary examination. So you may publish to the jury or show to the jury. So this would be part C of exhibit 1.
Thank you, Your Honor. Your Honor, if I may, I'm not sure where that's coming from.
I think it's coming from the other courtroom, correct? Or is that here? Jeff Simmons. I think it's a video sound from another video. So for the record, anything found on sound wise is not from our video. People's Exhibit 1C. And it's roughly 8:52:33 on the video for this file.
Open the door, please. You need to come out of the vehicle. Why not? Get out of the vehicle. Get out of the vehicle.
So it's approximately 8:53:28 on the video, and these same individuals at a door on the 6th floor on October 16th, 2022.
And Ms. Farr, that apartment that was entered, can you tell us what apartment that was?
610.
And again, to your knowledge, that person has no authority to be in that apartment.
I'm sorry, what?
To your knowledge, that individual who entered has no authority to be in that apartment.
Correct.
Do you have any knowledge who lives at 610 again?
Eileen Jacobs.
And at this time, are you aware where Eileen Jacobs would have been at this moment? At this moment in time, do you know where Eileen Jacobs would have been?
No,
Is this the video she came and spoke to you about?
correct.
Okay, did she tell you she?
Objection, hearsay.
Response?
I believe it's admissible for prelim to possession and entry pursuant to Michigan Rule of Evidence 11101B8.
Response?
That's not what the question's about. Mr. Wisty is trying to meet one of the elements, which is that there was a person present in the dwelling. And that would be inadmissible hearsay to which the exception is not applicable.
Mr. Wisty, response?
Believe it, the argument would be that it goes to entry, the idea she's there, she's got possession, she had entered there. That would be the people's argument, Your Honor.
All right. Well, I think I can substantively say that somebody's present in the apartment at the time. But what that person said would be hearsay unless unless there's another exception to it. Are you indicating it for that?
It's a hearsay exception unless for hearsay that goes to possession, entry.
And that's pursuant to,
Michigan Rule of Evidence 1101 paren B paren 8. And I apologize, Your Honor, I'm foolish enough to rely on my computer to look at it. Rules of
right,
Evidence.
so let me just make sure that I've got the same rule that you're indicating. So it'd be MRE 11110B.
11101 paren B paren.
I think David already did. Did you already ask if they'll turn that down?
No, I'm sorry, I didn't want to.
Just a little bit,
Yeah,
just
I got you.
because, just so it's coming through on our,
Okay.
thank you. So you're indicating for Arts 1101 at preliminary examinations, hearsay is admissible proof with regard to property, the ownership, authority to use, value, possession, and entry, and you're indicating it goes to that.
Yes, Your Honor. So the argument before the court, I think it's undisputed that the witness will be able to testify hearsay. That the individual doesn't have authority to use that apartment and who that apartment belongs to. The issue being raised here by defense counsel is whether or not she can say whether or not she is present in the apartment at that time pursuant to that court rule. That would be my argument at this time, is that goes as part of her possession, as her being in there, Your Honor, or use in this case being use of the apartment itself. So that would be the people's argument.
All right.
I think we do need to
So
answer
So I have found it 11101, parent 8. Any response to that argument, Mr. Hess?
Yes, Your Honor, that squarely identifies the source of the dispute. I'm well familiar with the court rule, but we've had some testimony from the witness about whether she had knowledge of whether this subject in the video had permission to be in that apartment. She testified that she didn't have that knowledge. But Mr. Wisty is attempting to introduce evidence that there was a person lawfully present in that apartment, which would correspond to element 4B of the jury instruction 25.2C. And it's my position that that carve out in the court rule with the hearsay exception does not apply to that. There's nobody here who can competently testify as to whether or not there was somebody lawfully present within that dwelling. So I'm asking, my objection is that the witness should not be allowed to say what Eileen Jacobs supposedly told her about whether she was or was not present in the
Thank you.
apartment at that time.
In regard to MRE 1101, parents 8, preliminary examinations. At preliminary examinations in criminal cases, hearsay is admissible proof with regard to property, the ownership, authority to use, value, possession, and entry, indicates possession and entry. In regards, this is hearsay testimony, but I'll allow it pursuant to 1101. The witness may proceed.
Thank you, Your Honor. And then may the record reflect, I'm just going to continue to show the video here. We are at 08:55:25. Ms. Farr, can you describe what we're seeing there?
We have him exiting apartment 610 with a bag in his hands.
Was the bag in his hand when he entered the apartment?
No, it was not.
No further questions, Your Honor.
Cross-examination, Mr. Hess.
Ms. Farr, you don't know who the subject in the video is, right?
I do not.
And you don't know if the subject had or had not permission to enter apartment 610, do you?
No, just what I was told from the resident. Someone entered her apartment while she was sleeping and stole her cigarettes.
But you don't know if the subject we're seeing in the video did or did not have permission to enter her apartment, right?
Correct.
You don't know if somebody else might have let that subject into the apartment.
Correct.
You don't know if Mrs. Jacobs may have misplaced her cigarettes or put them somewhere else?
She could have.
Okay. So what you do know is that you have reviewed this surveillance video and you've walked us through it, right?
Right.
Okay. I have no further questions, Your Honor.
Thank you. Any redirect?
Yes, Your Honor, just briefly. So as the manager of that apartment, you know who does and does not on the lease in the apartment, correct?
Correct.
You know Lean Jacobs is to be the person on that lease.
Correct.
And you did have a conversation with her where did you go through this video with her?
I absolutely did.
And when she saw the video and saw what happened, did she say this, what did she tell you?
She was in shock and she did not know the individual.
From that conversation, was it clear for me that this person was supposed to be in there?
Correct.
Does anybody else have permission to give people access to Ms. Jacobs' apartment? No further questions, Your Honor.
May this witness be excused?
The people, yes.
Mr. Farr, do you have any further questions? Can this witness be excused?
May I ask one more question?
Sure.
Ms. Farr, you said before that there was an aide. Is that somebody who goes in and out of Ms. Jacobs' apartment?
Yes.
Okay.
Because I manage a senior building, so we have a lot of residents that have aides.
Okay.
And if I can add to it,
That was my only question.
okay.
Any redirect based on the cross-examination, recross?
No, Your Honor.
May this witness be excused?
Yes, Your Honor.
Without any objection to this witness being excused?
No.
Without objection, the witness is excused. Thank you, ma'am, for your appearance today.
Thank you.
Mr. Wisty, any further proofs today?
Yes, Your Honor, I would be calling Officer Dylan Roos.
All right. Hey. Officer Royce, I'll have you come up here. Indicate your first and last name for the record.
Dylan
Right.
Royce,
Okay. And spell, please.
Dillonreust.
Okay, I'm gonna raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right, thank you. You may have a seat. Please project for recording purposes.
Yes, sir.
Mr. Wisty, you may proceed.
Thank you, Your Honor. Could you again state your name for the record?
Officer Dylan Royce.
What do you do? Where are you employed, officer?
I'm employed with the City of Lansing Police Department, and I currently serve the role as a Patrol Officer 1, PO1.
And in that capacity, did you come in contact with an individual named Leandre Olds?
Yes, sir.
And how did you come in contact with him?
I was dispatched to a call regarding a trouble subject, and after seeing some video footage, I ended up making contact with the subject near the apartment complex.
And when you made contact with him, can you elaborate on that?
Yes, we met. He was semi-hostile at first. I explained why I was there, and I needed to identify him for purposes of trespassing. After doing so, confirmed a few warrants out of a different jurisdiction.
What date did this occur?
I can't recall exactly. Several months ago. I can't recall.
This was in the last few months. Where did this occur?
The initial contact was at parking lot of 505 Town.
How was the lighting conditions?
Light. It was light outside. Early morning. My hours were usually between 8 and 4 p.m.
Did you get a good look at this person, Leandre Olds, that day?
I did. Yes, sir.
Do you see him here in the courtroom today?
I do.
Would you point him out and identify something he's wearing?
Yes, sir. Gentleman there in the blue shirt.
May the record reflect the witness has identified the defendant.
Any objections?
None for purposes of this hearing only.
Okay.
Thank you.
For purpose of preliminary examination, the witness has identified the defendant.
And then, Your Honor, if I may publish to the witness the video that's already been admitted. It's People's Exhibit 2. This is portion C.
Okay, so portion C is the portion, the last portion we watched. Is that correct?
Correct, Your
All
Honor.
right. Yes, you may publish.
And then, Your Honor, may the record reflect playing the video from approximately 084952. And then, officer, if you could just read this video, I'm gonna have a question for you following it. May the record reflect I paused this video at 085009. Officer, can you tell us who that person is in the video?
It appears to be the subject sitting there.
And would that be the defendant, Leandre Olds?
Yes, sir.
No further questions, Your Honor.
Thank you. Cross-examination?
Yes. Officer Royce, you had contact with Leandre Olds on October the 21st of 22. Did that sound right?
I can't say for sure, but it was several months ago. That seems correct.
Okay. You did not have contact with Leandre Olds on the date when this video was taken. Is that correct?
I can't see the exact date of the video, but I can't recall that.
You don't recall having any contact with Leandre Olds in conjunction with somebody being in the hallway of this building, right?
I would have to clarify which building that is. I remember seeing this. I was shown photos of this video,
Sure.
but I can't say that I saw him on this day.
So you recall seeing this video in the past?
I can recall seeing sections of the video. I can't recall if it was the video itself or if it was photographs from the video.
And another officer showed that to you?
A detective.
Did another detective showed that to you?
I believe so, yes.
That was not video that you had obtained yourself?
I do not believe so.
That was not part of any investigation in which you were involved, is that correct?
Yes, this video was not the video that I put in any type of report.
Okay. And the purpose of this officer showing you the video or photographs was to have an attempt by you to identify the subject in the video?
Yes, sir.
And today you've identified Leandre Olds as being a person you had an encounter with at some time in October of last year?
Yes, sir.
Okay. But you never encountered Leandre Olds in conjunction with this apartment building seen in this video, right?
No.
Okay. And your identification is based off of your visual comparison of the subject in the video to the person you knew as Leandre Olds, whom you met in real life, right?
It goes a bit beyond that, but that is part of it.
Okay. Just to continue beating a dead horse here, you didn't encounter or arrest or detain or interview Leandre Olds on the date when this video was taken, right?
I do not believe so, no.
Okay, no further questions. John.
Thank you. Any redirect?
Just briefly, Your Honor, so you were called into the investigation of your surveillance video. This is, and to determine who the person was, is that correct?
Yes, sir.
When you did that, you believe I'm viewing the video as the person sitting on the defense.
I do believe that.
No further questions, Your Honor.
May this witness be excused from the people?
Yes, Your Honor.
Mr. Hess, any further questions?
No, nothing further.
All right, witness, you're excused. Thank you for your appearance today.
Of course, thank you.
Mr. Wisty, any further proofs?
No, Your Honor.
Do the people rest?
Yes, Your Honor.
Mr. Hess, any proofs today?
No, thank you.
All right, motion for bind over?
Yes, Your Honor, I would move to bind over on count one, home invasion first degree. What we've got here is a videotape showing what has been identified as the defendant by Officer Roost, who has experience with him before entering an apartment building. That we've got testimony from belongs to Elaine Jacobs. We've got testimony from the part of the building manager that establishes venue. So she says that it's Elaine Jacobs' apartment. We also have hearsay testimony ruled admissible pursuant to the Michigan Rule of Evidence 11101(8)B that establishes that Miss Jacobs was in there at the time this occurred. Lastly, we've seen in the video the individual identified as the defendant comes in empty-handed and leaves with various property items. I believe at a probable cause standard, we have established the elements being an illegal entry without permission. While somebody was present and while in the dwelling committed a larceny, and I believe based on the video and the testimony today, those elements are met, Your Honor.
All right, and this, you're requesting bind over for the, this October 16th date?
Yes, Your Honor.
Okay.
And then it would be on and about October 17th.
Okay,
I believe October 16th is on or about October 17th.
all right. Mr. Hess, response to motion for bind over?
Yes, thank you very much, Your Honor. In addition to showing probable cause that the elements, every element of the alleged crime has been met to a probable cause standard, the people also have to show that the crime charge was committed by the charged defendant to a probable cause standard. The people have had Officer Royce identify the person sitting next to me as Leandre Olds, but Officer Royce had no connection to the response to this scene. He was shown the video by another officer. Officer Royce's testimony was that he's identifying Mr. Olds based off of this video. Now, just looking at it, it's a pretty high quality video, but still it's not able to, you can't make out somebody's facial features. It appears to be a stocky African-American male. Now, anybody can tell you that my client also appears to be a stocky African-American male, but how many men in this city, county, state, country meet that description? So that's not enough to rise to a probable cause standard to say that Leandre Olds is, to a probable cause standard, the person in that video. The apartment manager couldn't identify him. The best she could say is that she, through hearsay, that she believed the subject in the video did not have permission to enter that apartment. But that is not enough of an identification to a probable cause standard to show Mr. Olds, the defendant, as the subject in the video. As such, on that alone, I would ask the court to decline bind over. However, continuing as far as probable cause standard to the elements of the charged offense, the prosecutor has proceeded with the entry without permission theory. There was testimony from the apartment manager that this lady has an aide. Ms. Jacobs has an aide. This is apparently some sort of building for senior citizens. This aide apparently has permission to go in and out. We don't know whether this aide did or did not admit the subject in the video into the apartment. We simply don't know what the relationship is there. Anything else would be speculation. The people are alleging that when my client entered the apartment, he committed the crime of larceny. The only testimony of supposed larceny was the apartment manager, Ms. Farr, saying that Ms. Jacobs said that somebody stole her cigarettes. Well, the evidence we've been shown today was this subject in the video exiting this apartment with a bag. We don't know what's in the bag. We don't know if, we just don't know. It's all speculation, Your Honor. People visit their neighbors all the time. People pick up parcels of food, gifts, video games, bread, sugar, whatever. So it's speculation. I'm asking the court find there's not probable cause for that. Finally, over my objection, the court admitted hearsay that Ms. Jacobs said that to the apartment manager that she was in the apartment. The court's already overruled my objection. So that just becomes a matter for the record, but I'm also asserting that there was not sufficient evidence that there was a person lawfully present. So I'm asking that in light of everything that I've just stated, that the court decline bind over in this matter. Thank you.
Thank you. Any response?
No, Your Honor.
All right. The standard for a preliminary examination is a probable cause. Probable cause being the second lowest standard in criminal law. Reasonable suspicion being the only lower standard. Of course, it's not the standard for trying a case, which is beyond reasonable doubt. I'll indicate that the location of 601 North Cedar Street, City of Lansing, Ingham County, has been proven by probable cause evidence. The venue, which is the City of Lansing, has been proven by probable cause evidence. The date, which appears to be on or about October 16th, 2022, seems to be proven beyond probable cause evidence. If we look at just the crime itself, so I do most of this based somewhat on the testimony of Ms. Farr, and she has hearsay testimony that comes in under 1101. Hearsay is admissible to prove authority to use, possess, and entry property. She indicated that she observed the video with Eileen Jacobs, who is the owner of the property. She indicated that as the property manager. And she indicated that Eileen Jacobs indicated that she was present in the present sleeping and seemed angered, or seemed at least she did not give permission to whoever was in the video to go in while she was present and then take cigarettes while she was present. She indicated cigarettes to Ms. Farr. I'm uncertain, but we do have that. We do have some larceny from that while present in regards to the 601 North Cedar Street. So I believe home invasion first, the elements of did enter without permission, or 601 North Cedar Street, apartment 610, while entering in or present in, there was a person present. Eileen Jacobs indicated by 1101 that she was present and that she was stolen from, and that this person, whoever was on the video, did not have permission to take it from her. So I really come down to identification in regards to as to whether this defendant by probable cause evidence is proven to be the person who is in the video. The officer, Officer Royce, indicated through previous contact with the defendant and through video that it's the same person. That's one. So that's part of the probable cause evidence to bind over. There's also Exhibit 2, which is a freeze frame from the video, in which indicates that the person in the video is the same person that is in the courtroom. And I would indicate from a probable cause evidence that identification can be made as far as probable cause in regards to the individual who, for bind over purposes. I'm not sure whether that meets the threshold for beyond reasonable doubt, but for probable cause evidence, Exhibit 2 has been admitted and viewed and is suffice for identification purpose as to probable cause. So the court finds by probable cause evidence, the location, offense, venue, ID, and date has been proven by the people, and will bind the case over to circuit court as charged on home invasion first. On home invasion first, on the date in question, which is October 16th, at the apartment complex of 601 North Cedar Street in the city of Lansing. So the case is bound over as charged to circuit court. Your next dates will be in circuit court, sir. So keep in contact with your attorney public defender, Mr. Hess, and he will tell you exactly what dates that you need to be in circuit court in order to respond. Any questions, Mr. Wisty, about the court's ruling?
No, Your Honor.
Anything, Mr. Hess?
Nothing further.
All right. That's all for the record in the file.
Thank you very much, Your Honor.
Thank you.
In touch.